Hello students, welcome to the yet another interesting episode of Recitals in-Depth, where we are going to discuss the important topics which are featured under the section of Polity and Governance for the month of June. The topics are broadly following under the themes of elections, judiciary, key legislations, important bodies and various governmental schemes. So the next topic is e-Samriddhi, and this particular topic falls under the broader theme of governmental schemes. So this e-Samriddhi portal which the government of India has launched is basically trying to provide a technological solution to help the farmers of our country who are involved in the production of pulses, especially the tur and masoor pulses, so that this particular portal will help the farmers to gain a seamless process with respect to the procurement of pulses by the government of India. Now let us try to understand how the government is trying to help the farmers of our country with respect to the procurement of pulses by various agencies. So the first point that we need to discuss is the context, that is why the government is more bothered about the pulses and the subsequent procurement of these pulses by the farmers. Now ultimately we need to understand the standing of our own country with respect to the pulse production in our country. So India is the world's largest producer and consumer. But despite growing and producing the pulses in the maximum quantity possible in the world level, India is also the largest importer as well. And India basically imports like a great degree of pulses from the African countries, especially from the Sahel region. To name some are the Mozambique. Now, the whole point is that since India wants to have a very self-sustaining economy with respect to the pulses, and pulses form a very important dietary component in Indian food and dietary habits. And that is why when India is trying to import a lot of pulses from the country, other countries, it is actually putting a burden on our own fiscal resources, since our current account deficit will be increasing. So what the government has thought is that by providing higher minimum support prices to the 5 pulses which the farmers of our country are growing, so that with increased prices of the MSP, it will lead to increased income of the farmers. So ultimately farmers will be on a very benefiting tendency. And apart from this, since India is not self-sufficient with respect to the production of the pulses, it leads to a greater degree of price volatility. And to actually reduce this price volatility, which actually impacts the urban consumers or the rural consumers, Government of India, by the Department of Consumer Affairs, they had started the Price Stabilization Fund. And what is the purpose of this Price Stabilization Fund? Is that it creates a buffer stock of the pulses, so that whenever a tendency occurs that the prices of the pulses are fluctuating in the global or the domestic market, in that case government will try to increase the procurement of various important pulses by the various procurement agencies, so that ultimately it will again benefit the farmers. So to curb the price volatility of the various pulses in our country, government is also maintaining a buffer stock, and this buffer stock ultimately are being fed by the various procurement agencies, and these procurement agencies are paying like the remuneration to the farmers vis-a-vis the MSP, that is the minimum support price or the prevailing market price. Now, what government had thought is that the procurement agencies will be providing the money to the farmers in a seamless way. However, that is not possible because farmers are present almost all across the country, and if a farmer has to send or if the farmer has to sell their produced pulses to the procurement agency, many a times a farmer faces a lot of problems with respect to the logistics, packaging, movement of the produced pulses. So Government of India came up with a very good solution, that it provided a e-Samriddhi portal. E-Samriddhi portal, which is a web-based solution, so as to make the procurement and the payment system with respect to the pulses of our country in a very seamless manner. Now let us try to understand how does it function. So basically, this e-Samriddhi portal tries to link the farmers and the procurement agencies in a unified platform. So both the farmers and the procurement agencies are registered on the e-Samriddhi portal. Now, ultimately, whenever a farmer is trying to get themselves registered in the e-Samriddhi portal, it uses a 3-step verification processes. That is, this e-Samriddhi portal demands good degree of data from the farmers. What kind of data they are demanding from the farmers? Firstly, their Aadhaar details. Secondly, their banking details. And thirdly, about their land details, so that e-Samriddhi portal will be able to create a very aggregated data with respect to the farmers and what kind of and what amount of pulses these farmers are willing to sell over the e-Samriddhi portal to the procurement agencies who are procuring these pulses for the price stabilization fund or any other funds which can be maintained by any state government of our country as well. Now, similarly, the procurement agencies also has to get themselves registered under the e-Samriddhi portal. Okay, now what happens is that during the when the two of the stakeholders, that is the farmers and the procurement agency, get themselves registered, then the procurement procedure starts. And how does the procurement procedure will start? So definitely, as the procurement agencies will be knowing about the various banking details and the production details of a particular pulse by a registered farmer, so the procurement agency will purchase using the e-Samriddhi portal the pulses, and it will provide a very unique tag to the pulses which has been procured from a particular farmer. So every bag or every rucksack bag of the pulses which has been procured through the e-Samriddhi portal will be provided a unique QR code, so that ultimately the farmer will be able to track the position of the procured pulses and the subsequent payment which has to be made by the procurement agencies to the respective farmer. And in this way, it is very easy to imagine that ultimately it provides for a lot of transparency in the process, transparency and accountability, so that no procurement agency can just actually take the bags of pulses from the farmers and not to pay them back. And secondly, it will go for very accurate estimation of what amount of pulses are the procurement agencies are actually procuring from the farmers of our country, and which is going to the price stabilization fund, which is used to control the price volatility of the pulses in our country. So it is a very beautifully designed technical tool which is becoming a very win-win situation for every stakeholder which is involved over here, whether be it the farmers or the procurement agencies or the consumers of the domestic pulses that we are growing, since the consumers will be able to purchase the pulses in a normal price ranges. Okay, so this was all for this particular topic. Now let's come to the second topic, which is Lok Adalat. Now this particular topic is also hailing from the broader theme of judiciary. Now why we are trying to understand this particular topic? So recently, since it is the 75th year which is running for the establishment of the Supreme Court of India, to honor that particular event, the Supreme Court of India is going to conduct a Lok Adalat sessions from 29th of July from this month till, which will go on till 3rd of August. So before we go on and discuss the various aspects of Lok Adalat, we need to understand the basic need, that what was the need to shift to the Lok Adalat, and why the Lok Adalat forms a very significant pillar with respect to the administration of justice in our country. Now, as we already discussed in our previous topics that we had studied, whenever we discuss some certain topics with respect to the judiciary, always one very important topic comes to the fore, that is the case of judicial pendency. judicial pendency or backlogs. Now, we had noted earlier also that according to the National Judicial Data Grid, roughly almost 5 crore cases are pending in variety of courts in our India, right? Starting from the Supreme Court of India and going down till the taluk level district courts. So almost 5 crore cases are pending in our country. And why these the cases are burgeoning in nature? Because ultimately the courts are resolving the disputes in a very systematic and a procedural way. So ultimately the courts have to follow a lot of procedures which are prescribed by Indian Penal Code or Code of Civil Procedure or Code of Criminal Procedure. And the courts have to provide the resolution to these disputes following the procedures which are prescribed by the relevant laws, and apart from it, whichever the law through which the dispute belongs to. Now, the procedure which are suggested by the IPC, CRPC or CPC are extremely complex and very tedious, and ultimately because of this it is extremely time taking. And because of the inherent nuances of the procedures which are involved in the dispute resolution system of our country by the courts of law, these things make the entire process of justice delivery to be very, very cost intensive. So the normal people of our country who are very poor or who belong to the weaker sections of our society, they do not have that much amount of disposable income or resources that they can pursue their disputes in our courts of law because of the delays, the procedural and the inherent delays to get the substantive justice, and also because of the cost that has to be incurred, because every party who wants to get represented in the court of law, they want to pay fees to the court, they want to pay the fees to the lawyers, and they want to pay the fees to the registrars as well for the documentation, etc. So although the process looks very linear, it involves a great degree of cost associated with it. And that is where the whole seed or the origin of Lok Adalat lies. So what is Lok Adalat then? So Lok Adalat is nothing but a type of alternative dispute redressal mechanism. What do we mean by alternative? Alternative is nothing but another mode of providing justice which is more driven through natural justice and which is devoid of the procedural norms which have been provided by the various laws. So alternative dispute redressal mechanisms are not divided by the procedural norms, and since these mechanisms are not under the premise of procedural norms, they are bound to be more speedy in providing justice. Now, what are the various types of ADRM? There are many types of it. For example, conciliation, mediation, arbitration, and one of the most unique indigenous way of dispute resolution is the Lok Adalat. And this is what we are going to discuss very holistically in this particular topic. So for you guys to understand these topics very better manner, we try to map the topic of Lok Adalat, like ultimately where we are going to locate this particular topic in the entire realm of alternative dispute redressal mechanisms. Now, what do we actually understand by Lok Adalat? So since you already noticed, it is a type of ADRM which has got statutory backing in our country by the Statute of Legal Services Authorities Act of 1986. So this particular act provides the bedrock for the Lok Adalats in our country to actually provide speedy justice. Now, what does the Constitution say about providing ADRM? So, Indian state is obligated under the Article 39A, which falls under the directive principles of state policy, as you guys are all aware. So what does the Article 39A says? It says that the state is bound to provide free legal aid to the poor and weaker sections of our society. Who are these weaker sections? To name some, say victims of trafficking, women, SC, ST, and etc. So ultimately, the entire agenda and the motto of Lok Adalat is to provide very speedy justice, which is based on the principle of opportunity. That since if any particular person is poor or is coming from a weaker section of the society, so because of their attribution to that particular social class or status, it should not devoid them of getting justice in our country. That is the core essence of Article 39A of the DPSP. So ultimately, in providing the dispute resolution by the way of Lok Adalat, what kind of cases can the Lok Adalat actually put under its own jurisdiction? So the cases which is available under the jurisdiction which is provided by the Legal Services Authorities Act of 1986 is all the offences which are non-compoundable in nature. Non-compoundable in nature. What do we mean by non-compoundable? These are those crimes or offences which are not heinous in nature. Not heinous in nature and cannot be compounded with respect to any kind of monetary payment or out of the court settlement. For example, the cases which cannot be tried are, say, attempt to murder or rape, etc. So these are the cases which are not available under the jurisdiction which has been provided to the Lok Adalats in our country. Now, coming to the next topic, which is what are the various types of Lok Adalats which are present in our country. So ultimately, there are three types of Lok Adalats which are present. So the first is the National Lok Adalat, which are held on a specific subject matter every month for a single day throughout the country in all the courts, right from the Supreme Court of our country to the high courts or to the taluka level courts. So these are temporary in nature. The second type of Lok Adalats which is present in our country are the permanent Lok Adalats, and these permanent Lok Adalats are created to actually resolve disputes which are quite recurrent in nature. To name some, for example, if you are driving a vehicle and if you are not carrying your driving license or RC book with you, or you are not having your PUC report along with you of your vehicle, so such kind of tickets or such kind of offences can be clubbed together and can be resolved in a permanent Lok Adalat, which will not take the routine time of the normal courts of law. So that we'll be able to take a greater amount of time out of the pendency which is already persisting in the normal courts of law. And the third is the mobile Lok Adalat, which are organized in various parts of the country, since they travel from one location to another location, and that is why the name mobile Lok Adalat, since it is moving from one place to another. Now coming to the next slide is the how is Lok Adalat constituted. As we already noticed that the legal authority or the statutory basis of constituting a Lok Adalat comes from the Legal Services Authorities Act of 1986. Under this act, it provides for the creation of National Legal Services Authority, apart from it, State Legal Services Authority, District Level Legal Services Authority, Taluk Level Legal Services Committee. Okay, so ultimately, whenever there is a constitution of Lok Adalat at the state level, so ultimately the state level authority is being provided to the state level legal service authority, that is SALSA in short. So ultimately it is the SALSA which is the organizing authority which organizes the establishment of Lok Adalats in that particular state. And what does that Lok Adalat will comprise of within the state level? So it will comprise of a sitting or a retired high court judge or a sitting or a retired judicial officer. Apart from it, apart from the person who acts as the chairman, there are two other members who will be associated with the who will be associated with the Lok Adalat, which has been constituted at the state level. And who are those two members? Of whom one or both of a member from the legal profession, and one has to be a social worker, who are working in a very, very diligent manner in taking justice to the poorer and weaker sections of our society. At the High Court level, there are High Court Legal Services Committee, which constitutes the bench of the Lok Adalat, comprising of a sitting or a retired High Court judge, which will be basically providing very swift justice with respect to the Lok Adalat. At the district level, the organizing committee, as we already noted, is the District Legal Services Authority, which again will comprise of a sitting or a retired judicial officer, and two of the members will be from one from legal profession and one from social worker side. And these social workers are those people who are actually trying to take justice to the grassroots by providing equal access to the justice based on the equality of opportunity. And at the taluk level, the symmetry is same. The taluk level legal services committee will be the organizing committee. Again, the chairman will be a person who is retired or a sitting judicial officer, and apart from it, joined with two other professional members, one from the legal community and one from the social working community. Now, what are the major benefits which is associated with the functioning of the Lok Sabha? As we already noted, that the major need or the essence for the creation of Lok Adalat was the judicial pendency and the cost associated with it. So the one of the most important benefit is the free of cost services which is provided to the petitioner, since no court fee is charged and no fee is charged from that particular plaintiff who have approached the Lok Adalat. And if in case a court fee has been charged and if that particular issue has been resolved in the Lok Adalat, it will be made sure that that particular court fee will be refunded to that particular plaintiff. The second important point we had already noted, that the procedural flexibility and the speedy trial. Since the Lok Adalat are not bound by the procedural norms which are established by either by the CRPC, IPC or CPC, ultimately they are free to create their own procedures which abide by the theory of natural justice, which leads to speedy trial and speedy dispensation of justice. Thirdly, since the procedural norms are not fixed, it follows a very user-centric procedures. It will avoid any kind of delays, and ultimately it will provide the commitment to the accessible and efficient justice delivery, which is our also constitutional obligation, as we already noted under Article 39A. And ultimately, in the long term, it will create more and more trust with respect to the judicial institutions in our country. So this was all for this particular topic. Now let's come to the next topic, which is criteria for awarding death sentence. So this whole issue of capital punishment has always been under debate for one reason or another. And recently one more important issue had happened, that ultimately the president of our country, she rejected the mercy petition of a person named Muhammad Arif. And who is this Muhammad Arif? This Muhammad Arif person was involved in the terrorist attack at the Red Fort in the year of 2000. So, in this topic, we are going to learn about, in short, about the various clemency powers of the president, which the Constitution of India has provided to the president. And secondly, more importantly, how does the Indian Constitution and the Indian legal system view capital punishment, and whether it is desirable for our country to keep the process of capital punishment in our statute books. So now let us start with the topics. That is, we already discussed with the context. So before we actually go on and discuss the various criterias and various case laws with respect to the capital punishment in our country, firstly we'll try to see what is the clemency powers of the president very briefly. So Article 72 of our Constitution provides the clemency powers to the president, that the president, which is the head of the state and the head of the executive, he or she will be able to provide pardon, relief, or there is one very good acronym for it, that is PCRRR, that is The President of India is empowered to provide pardoning powers, to commute the sentence, to provide remission, respite, and reprieve. And it has been observed through the study of various political systems across the world that almost all the head of the states across the world has similar kind of clemency powers. So the Constitution of India has also provided this clemency powers to the President of India by being a virtue of the head of the state and the head of the executive as well. Now, what do we actually understand by the term capital punishment? So capital punishment is the most severe kind of punishment which can be given to any accused after having the due conviction, that ultimately the state is going to take their life. And according to the Amnesty International, which is a very well-known international organization working for the human rights and advocacy towards the protection of the human rights, it says that the practice of providing capital punishment through various statute books in various countries is being practiced in almost 55 countries. Okay. Now, the whole important point that we need to discuss over here is that what is the rational and legal logic behind providing capital punishment. So, of course, again, the whole side is debated a lot, and there are two set of thinkers with respect to the capital punishment, that whether we should go ahead with the practice of capital punishment or should we actually inhibit the various statutes and should we take out the event of capital punishment out of our statute books. So what are the major arguments for the continuance of the capital punishment? The first is deterrence. So majority of the proponents who want the continuation of capital punishment, they feel that ultimately when there is a capital punishment in our country, it will create the fear, and the fear which will create a deterrence, so that if any person will be hanged in our country for committing a particular crime or a heinous crime, then because that event will be known in our society, so it will create a sense of fear and deterrence among the societal members so that they will not go ahead and commit such heinous crimes. The second important thing or argument is the retributive justice or retribution, which means that ultimately it will lead to the avengance of the particular crime which has been committed on a particular victim. So this is based on the philosophy of eye for an eye, so that ultimately it will lead to the closure of that vengeance a victim holds in their heart. So when the convict person will be no more, ultimately it might lead to assuage of the vengeance a person is holding in their heart. And the third important point which the proponents of capital punishment they often quote is the maintenance of the social order, that ultimately if the people who are getting convicted for committing such heinous crimes, these people are not to be present with that particular society, and because of the capital punishment, since these people will be dead, the entire social order will be preserved, since these people will not be able to commit similar kind of crimes. Okay, now these are the major three arguments with respect to the continuation of capital punishment. However, what are the major arguments against? So the first point that we need to note over here follows from the first point of the arguments for itself, that is lack of deterrence. Various researches have shown that despite having the capital punishment provisions in our various statutes, what we have observed is that it is not able to create enough deterrence. So even after having gone through various kind of capital punishments in a country, the same kind of crimes keeps on happening. And that is also a cause of concern. That is ultimately challenging the fundamental premise with respect to the continuation of capital punishment, that it is able to create deterrence. But however, after a lot of research, it has showed that the capital punishments are not able to maintain that deterrence, or they are not able to deter the people from committing that particular mistakes. The second important argument which is against the continuation of capital punishment is the risk of wrong execution. Now ultimately it is the court of our countries which are which are actually deciding whether a person will be provided the capital punishment or not. However, one important thing we need to note over here is that the court of law functions on the basis of evidences, and evidences and the investigating agencies are always prone to get vulnerable, or it can get risky in a way that we are not able to ascertain whether that particular person has committed the crime or not, because the credibility of the evidences and the credibility of the investigating agencies can always come under the doubt, and ultimately the investigating agency can work under various motivations or various malified motivations as well, which never comes to the fore while that particular trial is going on, and ultimately it can lead to the risk of a wrong execution as well. And these are the two major important arguments which are there against the continuation of the practice of capital punishment. Now let us try to see, now we'll try to see that what does the Indian legal system and the political system holds for the practice of capital punishment. So what does the constitution say about it? So constitution, under the constitutional framework, capital punishment is very valid. How? So ultimately under the article 21 of the constitution of our country, it provides that no person shall be denied their personal liberty and life except under the procedure established by law. So what does the article 21 means over here with respect to the capital punishment is that if the procedure which has been established by the law of our country is fair and reasonable, then in this case the state can create such laws which actually promote capital punishment. Okay. And what does the law of our country says? So as we know that the IPC, that the Indian Penal Code of our country, is being replaced by Bharatiya Nagarik Suraksha Samhita. In the IPC, it had created a category of 12 crimes which were punishable with capital punishment. However, in the Bharatiya Nagarik Suraksha Samhita, this has been increased to 18 crimes. So for example, to name some, like for example, if there is an event of ghastly gang rapes or rape of a child or murder by mob. So these are such category of crimes which are actually put under the statute which prescribes capital punishment for commission of such crimes. Apart from it, there are certain different laws and statutes also which prescribes the commission of capital punishment. Now, ultimately, we need to understand that what opinion does the Indian judiciary holds with respect to the capital punishment. Now, as Supreme Court has noted in various judgments, so the first judgment is Jagmohan Singh versus UP, which was taken place in the year of 1973. Again, there is a case, important case by the name of Rajendra Prasad versus UP, 1979. An important case, that is Bachchan Singh versus State of Punjab, which happened in 1980. In all these three cases, the Supreme Court basically upheld the validity of capital punishment in our country. However, in the last case, that is the Bachchan Singh versus the State of Punjab, Supreme Court, it initiated the deliberation or a discussion on a very important doctrine, which is the doctrine of rarest of rare. And in this doctrine, the Supreme Court, in the judgment of Bachchan Singh versus State of Punjab, it noted that although the Indian Constitution and the various laws which prescribes the capital punishment are legally correct, however, the judges of the court, while providing any kind of capital punishment, they should always go for this rarest of rare doctrine. And however the crime has been committed, but any convict has to be provided the capital punishment in the rarest of the rarest case. And the Supreme Court elaborated this particular doctrine in the cases of Machi Singh versus State of Punjab, which happened in the year of 1983. And in the Machi Singh versus State of Punjab case, the Supreme Court laid down very elaborate guidelines with respect to which cases are to be considered as rarest of rare. So the first point which it mentioned was the manner of commission of murder. That if the murder is committed in a very heinous, in a very gruesome and in a very inhuman way, like it had happened in the Nirbhaya case, if you remember. So in this case, it should be provided a capital punishment. Apart from it, judge also has to note the motive of that particular crime as well. Apart from it, whether the crime was of antisocial or socially abhorrent nature. That is, certain times, as it is quite evident in the news pieces as well, that we come across certain news that a 1-year-old baby was raped. So such kind of crimes are very socially abhorrent, and it evokes and arouses a lot of indignation within our society. So such kind of cases will also fall under the rarest of rare case doctrine. And lastly is the magnitude of the crime. So if a particular convict person has gone along inflicting crimes on various other individuals, for example, there are various cases of serial raping and serial killing. In such cases, the judiciary has described these things as a rarest of rare doctrine, and these cases has to be provided capital punishment. Now, coming to the next section, which is what are the various factors which are considered while deciding the mercy plea. Now, after the judiciary has pronounced the capital punishment, and when the convict has actually used their review petition and the curative petition, if the Supreme Court allows so, ultimately such kind of petitions lands in front of the President. That is, utilizing the power of the President given under Article 72, that is the clemency powers, so that they approach the President with a hope that ultimately the President will, if not pardon them, at least the President can commute the nature of the capital punishment, so that from the death punishment, President can commute it to lifetime imprisonment. Now, what does the President and the concerned ministry elaborates on the point that how they actually consider with respect to whether they have to go for the mercy plea or not. Now, we need to note one thing over here, that the power provided by the Constitution of our country under Article 72 to the President is not discretionary in nature. And the President has to exercise their clemency powers again with the aid and advice of the Council of Ministers. And it is the Ministry of Home which actually provides the advice to the President. Okay, so that is why these are the major points which are considered by the Home Ministry with respect to entertaining of the mercy petitions. What is the first thing? That is ultimately the MHA will take into notice the personality of the accused, like age, sex, their social group, whether they are belonging from the poor class or from very depressed classes like scheduled caste or scheduled tribes, etc. And the cases in which the appellate court expressed doubt as to the reliability of the evidences. As we already noticed while we were discussing the various points with respect to arguments for and against the death penalty, that it might be a possibility that the credibility of the evidences are not very sure and are not established. So in certain cases, the MHA always provides for the plea for the mercy petitions. Apart from it, it also looks for the cases where it is alleged that the fresh evidences are emerged after the conviction of that particular person. And when the High Court on appeal reverse the acquittal or increase the sentences which has been provided, and if there is a difference between the opinion of the benches of the High Court with respect to what kind of punishment they should actually give to that particular convict. Now, ultimately, these are the major pointers which the Ministry of Home Affairs actually considers before entertaining the plea for the mercy petition in front of the President. One very important thing we need to note over here. What if the President receives that mercy petition and they keep on sitting on that particular mercy petition and ultimately it rejects the mercy petition? So, can the petitioner again go to the Supreme Court? So the answer is yes. It has happened in the past, and especially in the year of 2013 or 2014, that ultimately in a very important case which set a very important judicial precedent. The case goes by the name of Shatrughan Chauhan versus State of UP. So what had happened is that the President of India was having a mercy petition appeal of a particular individual. Now, President of India provided a lot of delays with respect to the clearance of those mercy petitions of those convicts whose death sentences were going to be executed. So what the Supreme Court noted in this particular judgment, and to be very specific, P. Satasivam was our Chief Justice at that point of time. What he had noted is that due to the inordinate delays by the office of the President in actually clearing the mercy petitions by the President, it had resulted into a lot of mental agony and psychological stress for those convicts. And because of that, Supreme Court, what it did, it commuted the death sentences which it had provided to such convicts to life imprisonment. So these are the various aspects that we need to keep in mind while studying the topic of capital punishment. Now coming to the next topic, which is coalition government and economic reforms. As we recently concluded our 18th Lok Sabha elections, and our Honorable Prime Minister Modi ji has again become our Prime Minister and has created a third government. However, one very structural shift has taken place. The earlier two governments were government by the single party majority. However, this time BJP were not able to secure enough seats so that they can make a government on their own. And this time it involved more coalition partners. So it was also going on a debate in our media circles that whether coalition government is good for the economic reforms and the economic performance of our country. So now let us try to examine it with help of our previous examples as well. So before we go on and discuss India's economic performances and growth rate over the years with respect to single party government and the performance of our economy with respect to the coalition government, first of all, let us try to distinguish between the basic nature of government with respect to the single party government and with respect to the coalition governments. Okay. So what are the major advantages with respect to the single party government? As we know, as we had already seen in the previous governments from 2014 to 19 and 19 till 24, that ultimately it provides a lot of political stability and reduce political conflicts. Since a single party is ruling the legislature or the parliament of our country, so decision making is quite swift and there is more degree of political stability since there is less of political tug of war with respect to various coalition partners. So it provides for a lot of political stability as there is no or very less political conflicts. Apart from it, a very clear accountability is established. Since only one party is ruling, the public of our country and the opposition parties which are present there in the parliament also, they can hold the ruling party to be very accountable in a very clear manner, since there are no other stakeholders who are involved in running the government. And the third is low electoral expenses. Now, since without frequent elections and since there is no coalition government and there is no political tug of war, so election expenses will be less because the political party which is running the government, they are not that afraid of losing their power since they are commanding a great degree of majority in the parliament. And the last is it provides us very strong leadership. So it increases the majesty of our country also in the international or the global forums as well. As we have already witnessed in the last 10 years also that India gained a lot of prominence within the various global forums, and we have to give the credit to our Honorable Prime Minister Modi ji. However, on the same footing, what are the various advantages which are being provided by the coalition governments of our country? So the first is the inclusivity and the representation, that it provides for representation of the smaller parties and inclusivity of various social groups which actually votes to the power their representative smaller parties. So the ultimate government is extremely diverse and democracy stands on the bedrock of diversity. That ultimately if there is a diversity of ideas and diversity of representation, the more healthy the democracy will be. The second is collaborative decision making and reduced polarization. Now, since a coalition government will be having different stakeholders or different coalition partners, every coalition partner will be having their own set of ideologies and own set of priorities and vested interests. So the entire decision making and the policy making by the government will have to keep in mind that all coalition partners are happy and satisfied with the decision of the government. So ultimately it leads to a very deliberative and a very collaborative decision making process, which is again very good and healthy for the credibility of the political institutions and the credibility of the democratic decision making. And the third important point we need to note is the checks and balances with respect to the accountability. As we already noted that ultimately it was quite clear accountability in the case of single party government. However, because of the presence of more coalition partners within a government, one coalition partner will be holding the other coalition partner to be accountable, and it is not only the opposition or the people of our country who will be holding the government accountable. So the governmental partners will be themselves holding the governmental partners to be accountable, and that is again very important from a political point of view. However, although we have seen the advantages, but we need to discuss the disadvantages in a more holistic manner. Since it is looking quite rosy, and it might feel that okay, it is quite desirable to have coalition governments. However, it holds their own inherent cons as well. Now let us try to understand it. So we'll start with the coalition government. So what are the various negatives associated with the coalition governments? So as we already discussed, since coalition government will comprise of different partners, more number of partners, so ultimately any decision will be able to be fructified after a prolonged discussions, negotiations, political tug of war. And what happens is that in that case of political tug of war, where every coalition partner is not happy and every coalition partner is trying to get their vested interest flown through the governmental policy, it leads to a policy gridlock or a policy paralysis, which is not good for the governance of our country. And governance of our country is directly linked to the economic growth and the economic reforms of our country. Apart from it, it can lead to unpredictable policies, instability and uncertainty. Since there are a lot of priorities and vested interest, the policy predictability of that particular coalition government is quite low. And the investors who actually wait for policy certainty so that they can actually invest their various resources for the growth of our economy, they are not able to invest accordingly. So ultimately, because of the policy instability, the investment level, especially by the private parties, it goes down, which leads to poor growth rate. And thirdly, it also goes for patronage politics, because ultimately the coalition government is inherently weak because it is tying up a lot of political parties together. So they definitely would want to patronage their own political agendas and their own political subunits so that the continuity of the government is assured. And fourth is, it provides for weak leadership, because ultimately the leadership of the coalition government is not able to take decisions according to their own will, and they are bound to follow the directives of the other coalition partners also. However, the scene is just reversed when we have a single party government. However, the single party government again comes with certain kinds of disadvantages. So the first is lack of democratic participation. Since one party is ruling, it might be a possibility that that particular political party has the support of one larger majoritarian social group. So it basically divides the formation of the government, and it basically takes away the value of diversity from that particular government. Apart from it, since it will be ruled by one larger social group, it might lead to majoritarianism, and ultimately it might lead to authoritarianism. Apart from it, there can be a threat of social discontent as well, since single party government will not be very receptive and empathetic towards the need of other social groups as well, and which can create a greater degree of discontent in our society. And lastly, it can lead to a potential for revolution as well, since prolonged suppression of political freedoms and discontent can lead to development of more and more piled up energy within the society, which can lead to a greater degree of violent revolutions in our country as well. Now let us try to see how does the coalition governments have performed over the years. Now there was a basic discourse which was going on in our society just after the election results had come, and there was a greater threat or anticipation within the society that ultimately coalition governments, since they are slow in taking the decisions and since it provides for a weaker leadership, will it cause slower economic growth in our country? And this is what we are going to analyze it over here. Like over the years, how has the coalition governments have performed? Now you will be surprised to know one very important term, that is Hindu rate of growth. Now Hindu rate of growth was coined by a very well-known economist by the name of Raj Krishna. And this Hindu rate of growth used to denote the very sluggish rate of growth of 2 to 4% of the Indian economy, which it witnessed from the 1950s till late 1980s. And one thing we need to note over here, that from 1950s to 80s we were having a single party majority government, and that particular period is notoriously known for its Hindu rate of growth, which was basically to denote the very sluggish rate of growth of the Indian economy, ranging from 2 to 4%. However, when the Indian political landscape saw the emergence of the coalition governments, especially from the 1981, and we need to give the credit to the government of the PM PV Narasimha Rao government, which was essentially a minority government, but it provided for one of the most fundamental structural reforms which our economy had to see, that is the liberalization, privatization and globalization reforms, which basically reduced a lot of bureaucratic red tapeism. It gave away with a lot of tariffs or taxes, and it opened the economy to the foreign investments, and it opened the Indian economy for the various global investors who wanted to come in India and do business with us. Apart from it, although the Deve Gowda government, which started from June 1996 to April 1997, although it was very short-lived a government, however, the Deve Gowda government was quite active with respect to the reduction of the tax rates. And ultimately, when the tax rates reduced, the savings with respect to the people and the organizations, it improved, and ultimately those extra amount of money, it started circulating in the economy. Apart from it, they continued the economic liberalization process and allocated significant funds to the National Renewable Fund. That is important to know from the mains point of view, to support workers affected by industrial modernization. Now, in the year of 1999, when the Atal Bihari Vajpayee led NDA government had come, NDA government at that point of time took very important measures for the fiscal prudence, that the government should utilize the resources in a very, very prudent manner, that it should not go for splurge of the expenditure, so that the fiscal deficit will be in appropriate limits. And to attain that, they came up with the Fiscal Responsibility and Budget Management Act. Apart from it, the Atal Bihari Vajpayee led government, they also started with the liquidation of loss-making PSUs, so that it also provided for a lot of resource generation for the government, and it provided for a greater degree of economic growth for our country. And lastly, one of the most celebrated Manmohan Singh led UPA alliance, that is the UPA 1 and UPA 2, and it is also known as the rights-based regime. Rights-based regime, because during this time 5 rights-based legislations were passed, which provided for a lot of developmental activities in our country. And what were these rights? Right to education, right to food, right to information, right to employment, and right to forest right resources. So these were the major rights-based legislations which were actually enacted by the Manmohan Singh government, and it ultimately led to the creation of a foundation of a rights-based regime, so that the people in the coming times can actually take the help of these rights-based regimes so as to demand for second generation rights like right to health, right to housing, etc. So these were the major contributions of the coalition governments with respect to the economic growth and economic development in our country. Now let us come to the next topic. So the next topic is Central Excise Bill 2024. So recently the Central Board for Indirect Taxes and Customs, they floated a draft Central Excise Bill 2024 so as to take the suggestions from various stakeholders. So now let us try to understand what are the various provisions this particular bill holds, and ultimately what are the major functions of CBIC, that is Central Board for Indirect Taxes and Customs. So this particular topic is more important from the prelims point of view, because from the mains point of view this is quite narrow. However, we'll try to see what are the major provisions does this particular bill is containing, so that if a question is framed within the prelim examination, we'll be able to solve it. So what is CBIC which had floated this draft bill? So ultimately this Central Board of Indirect Taxes and Customs, short for CBIC, is a statutory body which is created by the Board of Revenue Acts of 1963, and ultimately it administers all matters related to indirect taxation in our country. Indirect taxation in our country. Now this CBIC works under the Ministry of Finance, under the Department of Revenue, and the chairman of CBIC is appointed by the central government only through the Appointments Committee of the Cabinet. Committee of Cabinet. And the primary function of the CBIC is to administer all the matters and issues with related to the indirect taxation of our country. Apart from it, it also creates a lot of policies and formulations with respect to the levy and collection of the indirect taxes in our country. Now, before we go on and proceed and discuss the various provisions with respect to the draft Central Excise Bill of 2024, let us try to briefly understand what is this Central Excise Duty. So, Central Excise Duty is nothing but an indirect tax which is levied on the manufacturing of goods, and not services. One very crucial important we need to note over here, that Central Excise Duty is not applicable on the manufacturing or providing of services, but only for the manufacturing of goods. And who is paying this particular Central Excise Duty to the Government of India? These are anyone who is manufacturing that particular good, or the manufacturers. So how ultimately it is different from the GST, which is the one nation primary agenda of the one nation one tax, that which subsumed all the indirect taxes. Since GST is a primary tax, that is the goods and service tax, it is paid by ultimately the consumer and not the manufacturer. But in the case of Central Excise Duty, it has to be paid by the manufacturer or any person who is manufacturing that particular good. Apart from it, GST, as the name also suggests, it goes for both goods and services. Okay. However, there are certain commodities like alcohol, tobacco, and certain categories of cosmetics which do not come under the ambit of GST, and hence these come under the ambit of Central Excise Duty. And the Government of India thought that it will come up with the Central Excise Bill 2024 because the previous excise bill was enacted way back in the year of 1944. So it's almost 80 years since the inaction of the previous excise bill. So to be more ready with respect to the times or the technological priorities of these times, and to make the entire process of levying and collection of the Central Excise Duty in a more seamless and a more advanced way and a modern way, the Government of India decided to come up with the draft version of Central Excise Bill of 2024. Now let us quickly look at the various important facets which have been mentioned in the draft bill. So firstly, earlier the Central Excise Duty was not levied on the goods that were manufactured under the special economic zone, but this bill is actually recommending the levying of Central Excise Duty on the goods which is being prepared under the special economic zones. Second one important point which is mentioned over here is that this particular bill provides for the eligibility criterion for the Central Excise Duty credit. Like, who are those categories of manufacturers? Categories of manufacturers will be enlisted in the draft legislation itself. Earlier, it was under the discretion of the Central Excise officers, and it was not explicitly mentioned in the bill. Now, the third point is extension of time limit for recovery of duties. That is, this particular bill provided that the Central Excise officers will be able to extract the duties out of the manufacturers. Earlier, it was 2 years of the time frame. Now, this bill has increased this thing to 3 years. Okay. Apart from it, the transition of credit from the repealed Excise Act to the new Act, that is, whichever the credit which were present with the manufacturers of a particular good, after the repeal of this Act, that particular amount which is credited to the manufacturer will be shifted to the new accounts of the manufacturer as soon as this new bill comes into the implementation. And the time for rectification of errors apparent on the face of records, it means that if there is a mistake with respect to the maintenance of the data, so ultimately it has reduced the amount of time for the rectification of the errors. And ultimately the sixth important point which we need to note over here is the reduction in the rate of duty for certain tobacco products. So it has reduced the rate of excise duty which is impingent on the tobacco products. However, this particular draft bill is actually open in the public domain, so that the various stakeholders, whether be it various chartered accountants or the manufacturers, can actually provide their suggestions with respect to how to make these draft bill a more inclusive one. Now let's come to the next topic. So recently, Justice M.S. Sonak, who is serving as a judge in the Goa bench of the Bombay High Court, became the first person to sign or register a living will. And ultimately, Goa is the only state and the first state to actually allow the implementation of the living wills in our country. So what do we actually understand by living will, and how is it different from the normal wills? Now let us try to understand it and analyze it. So what is living will? So living will is nothing but a medical directive. Medical directive which is created by any individual to be followed by their close family members or the medical practitioners in a case that particular individual is, because of certain illness, is not able to communicate. But communicate what? Their medical preferences, like what kind of medical services that particular person would want in case that particular person is not able to speak or that particular person has gone into a vegetative state, and about the during what conditions that the life support system should be withdrawn. So the living will usually comprises of the medical preferences of an individual, and at what instances and under what circumstances should the life support system should be withdrawn so that this particular individual will not survive. And ultimately this living will is extremely important in the wake of the passive euthanasia, that is withdrawal of the life support systems, so that there are many cases that an individual is kept alive by providing them with the ventilator support or in the essential food tubes, etc., so that the body is functioning. However, the individual is in a vegetative state. So in that case, if everything is predetermined with respect to how individual would be wanting to provide what kind of medical care to them, that is the core essence of the living will. Now one more important case it comes to the fore, like who all are those individuals who are actually duly eligible to make the living will. So this can be created by any person who is of sound mind and who wants to create a living will with respect to how do they want to be treated with respect to the medical or the curative medical services which are offered to them in case where that individual turns vegetative, that is they are not able to communicate their desires with respect to this particular life and with respect to the medical practices or the services which they are availing. Now what are the various elements with respect to of a living will? So ultimately it consists of basic details of the individual executing the will. Apart from it also entails the circumstances under which medical treatment shall be continued or to be withdrawn to avoid any ambiguity in case of terminal illness. The third important point we need to note over here are the details of immediate family members who will be authorized to give consent to refuse or to withdraw medical treatment on the behalf of the individual. You can understand the point 3 in a way that since this is an individual and they will have a family, so there has to be individuals who are enlisted so as to provide a consent that okay, it is fine that we should remove or withdraw, say for example, the ventilator services which are provided by the hospital, which is keeping this particular individual alive. Okay, so there has to be a immediate family members, details of those family members. Apart from it, it has to have a very detailed instructions regarding specific medical treatments such as resuscitation, mechanical ventilation, etc., tube feeding, that we already noticed. Apart from it, if an individual feels that when they are dead, they would want to donate their organs, whether be it eyes, kidneys, livers, so it should also be mentioned in that particular living will. Now, one thing we need to understand, that even if after making the living will, if a person goes into a vegetative state, such kind of situation, gruesome situation happens, that person lands into a medical condition where they are not able to communicate it, then the living will come to the action. So how does the living will comes to the implementation? This is what we are going to see over here. So the first point is, ultimately the medical practitioner will ascertain the authenticity of the living will which has been created. It might be a possibility that some enemy of that individual has created the living will for that particular individual. So what the medical practitioner will do is that, or that physician will do, is that they will take that particular living will to the judicial magistrate of the first class in that particular jurisdiction. Say for example, if that particular terminally ill person is in Delhi, so then the medical practitioner will take the living will of that person to the judicial magistrate first class of Delhi itself. That is why jurisdictional. Secondly, the medical practitioner or the physician will inform the executors. Who are those executors? These are the same executors who were present in the living will as the close family members. So this is quite logical that ultimately the doctors or the medical professionals have to provide the information to the close family members about the living will and about the medical condition, that ultimately this particular individual will be able to live only with proper life support, like for example food tubes or ventilators. Third step will be the constituting a medical board, that is the hospital in which that particular individual is admitted will constitute a medical board. Okay, and then this board will go through all the medical details of that particular individual and the details which has been provided in the living will. And according to the living will, if the medical board which has been constituted by the hospital, if they find that the medical conditions have arrived with respect to that individual, that he will not be able to sustain without any life support systems, then in that case it has to recommend that there has to be an execution of living will. Okay, and ultimately if the hospital's medical board is of the opinion that the situation has arrived that as according to the living will they should withdraw the life support systems given to the individual, then they should report it to the jurisdictional collector. Again in this case the collector of say Delhi about the proposal, and then the collector will create his own medical board, again the second medical board, which will visit the hospital and they will consult with the medical board which was created by the hospital, and then they will jointly come to the conclusion that whether the person is actually facing the similar medical conditions or not. And apart from that, ultimately then the medical board which was created by the collector of that particular jurisdiction will inform the judicial magistrate of the first class about the medical certainty of that particular individual's issue, and this judicial magistrate of the first class will again visit the patients and they will see whether the individual is actually facing the similar terminal ill situation or not. And ultimately after examining all the aspects, it authorizes, or the JMFC will authorize the implementation of the decision of the board. And the same case, the judicial magistrate of the first class, it also informs the high court of that particular jurisdiction about this particular case as well, as soon as the board has authorized for example, the execution of the living will. And lastly, in case of differences of opinion, had there been a case that there is a difference of opinion with respect to the executioners, that is the family members and the medical board, then this case can go to the writ petition in the High Court concerned, and the decision of the High Court will be final. So there has to be a very elaborate process, as we already learned right now with respect to the execution of living wills in our country. And this question can come very easily in our prelims examination. So now come to our last and very important topic again, that is the doctrine of merger and doctrine of stare decisis. Now, ultimately, whenever there are certain doctrines, ultimately these topics are related to the judiciary itself. So, ultimately these topics are more important from the prelims point of view, that there can be questions asking you about the definition or the meaning or the essence of such doctrines. And why this doctrine was in news? So recently the Supreme Court had mentioned that while exercising the power given to them under the Article 142, Article 142 comes under the exception that they do not have to follow the doctrine of merger and the doctrine of stare decisis. So what is this Article 142? Article 142 is a very special power provided to the judiciary, that for providing complete justice, they can pass any decree or any judgment so that the conflicting parties present in a dispute will attain complete justice. And for us to understand these things, now let us come to the next slide. So we'll start with the first thing, that is doctrine of merger. As the term itself suggests, that doctrine of merger, that is, it is providing for merger of judgments which the various courts of our country has provided. So what do we actually mean by that? It provides that ultimately that when an appellate court passes an order, the order passed by the lower court is merged with the order of the lower court. So for example, there are two courts. One is the lower court and other is the higher court, say High Court. So if a judgment is provided by the lower court, say judgment 1, and ultimately there was an appellate petition filed to the High Court, and then the High Court reversed the judgment. So while providing the judgment 2, ultimately this judgment 1 has to be merged along with judgment 2, so that ultimately it will lead to the establishment of a judicial hierarchy. Because whenever a judge is trying to provide a written judgment, so whenever there will be a merger of the lower court's judgment as well, so that it will reinforce the hierarchical structure of the judiciary, where decisions of the higher courts take precedence over the decisions of the lower court. And ultimately it will lead to the finality of the judgment also, because once a matter is finalized by the higher court, one should not come to the again to the higher court with a judgment of the lower court, so that ultimately it has to function as a court of record as well. And thirdly, consistency in legal precedents has to be there. That this doctrine helps maintain consistency in legal precedents, ensuring lower courts follow the rulings and interpretation of the higher courts. Although there are no statutory backing associated with this particular doctrine, but these things are followed as a legal tradition in our country. Now, what are the conditions required for the applicability of doctrine of merger? So definitely, since it involves the merger of two set of judgments, one provided by the lower court, one provided by the other upper court, so there has to be a decision or order passed by the lower courts. That is, there has to be an appeal, and then only there has to be two judgments on one singular case. Okay, and the superior court must either modify, reaffirm, or reverse the decision or order passed by the lower court. So even like there is no doctrine of merger if there is no appeal against the order of the lower court, and once the higher court reverses or modifies the judgment which has been provided by the lower court, then in that case the judgment which has been provided by the lower court is merged along with the judgment which has been provided by the higher court. Now the similar kind of thing is the doctrine of stare decisis. Stare decisis means that to stand by the decision and not disturb it. To stand by the decision and not disturb the undisturbed. So which basically means that it is a legal principle which directs the courts to adhere previous judgments. That is, it forces the various courts of our country to follow the legal precedents which has been set by various other courts in our country. So what do we mean by precedent over here? So precedent is nothing but a legal rule that whenever a higher court has passed a particular judgment or an order in a particular case, and if the lower court, or for a matter of fact any other court in our country comes again, like any other court of our country, they also face a similar case having similar circumstantial facts and situations, in that case that particular court will have to follow the precedents which has been established by the court of law in any part of our country. So in that case, there are two set of precedents. One is binding precedents, that ultimately if a court is there and in the same jurisdiction one more court was there which had created, or a higher court was there which had ruled in such a way that it has created a precedent, then that other court has to follow that particular precedent. However, apart from it, there is a persuasive precedents as well. It might be a possibility that, for example, Delhi High Court has provided for a judgment, so it set a precedent. Similarly, there is a Gujarat High Court, and ultimately this Gujarat High Court, facing the similar case, having similar circumstantial facts and scenarios, can get persuaded by the precedent, but it is not obligatory for the Gujarat High Court to follow the legal precedents established by the Delhi High Court. Why? Because these two high courts are functioning in exclusive jurisdiction of their own territories. And ultimately, two more important terms which we need to understand from the prelims point of view is, one thing is ratio decidendi. That is, this refers to the legal principles which a court decision is based. So ultimately, whatever the reasoning is, whatever the principles that particular court has used, that is called ratio decidendi. And another is obiter dicta, which means that whenever a judge is providing any kind of judgment, there are many other facets also provided by the judge on that particular judgment, which is not directly related to that particular case which is of the matter in that particular judgment, and that is what we call as obiter dicta. However, what do we ultimately mean by the obligation over here? That ultimately, since for any one particular jurisdiction, legal precedents create an obligation for the other courts also to follow the suit, so that it creates a larger legal homogeneity and the practice of legal homogeneity across the courts in our country. And what are the advantages, as we already seen? That since every courts of our country are following the same legal principles, it will lead to homogenization of the processes. It will reduce like incidences of redundant litigations which people can do. So such kind of things will actually save the time and energy of the judiciary and inculcates the flexibility in the judiciary and brings stability, certainty and the consistency of the law. So this was all for this month's Recital in Depth. I hope this was an informative session for you. Stay tuned for the next month's Recital in Depth. Thank you.